I may not be misunderstood. Don't take my lord. No, no, my lord. But I am very, very upset. Very, very upset, and I would put it across in the most soft and most respectful way which I can use humanly possible. Now I'm arguing this case. I'm not about your lordships. I'm completely upset. I'm completely angry the manner in which the courts in this country behave in MSMEs. That is objectionable, absolutely objectionable. Because the lawyers here doesn't open their mouth. They don't plead for their right. And that is the sorry state of affairs. No, 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 look here. Why should an MSME come as a beggar here? Why should the lawyer be a beggar here? No, no, no. No. Now today is I came here on the first round. I claim MSME rights. In a reply to the 13 notice, I said on MSME. Then in spite of that, this court, I'm a citizen of this country. I have the right to criticize. This court passed an order saying that I'm not entitled to the benefit. Then I took up the matter because there is no point in going to the division bench except the waste of stationery and time and money. I went to the Supreme Court. Supreme Court admitted my matter. The next day, they issue a fresh notice under section 13(2) and they come for taking possession. Where is this? Is this these people representing the common people have no right? Only your lordships will hear the bank lawyers? No, madam, the question, this is a begging an answer. This question begs an answer. Are this code for banks and financial institutions? No. I'm answered, my lord. We are all accountable to the people. Everybody, your lawyer is accountable. Your lordship is far more accountable. We are all accountable. We are not, my lord. We are not embarrassed. No. Everybody, I'm not personal. Nothing personal. Nothing personal. When I speak, I am not speaking about Justice Balaji. I am speaking about the institution, the institutional damage. Because this has come because the lawyers has become servantile. Lawyers doesn't speak. Lawyers beg. Go to the Supreme Court. Your lordship will see only that beg. That is why should the man should come? I don't want. I gave up surface parties. I gave up banking parties long before I am again to come to the field because of this injustice. This is injustice. No, my lord, now let me take your lordship to the orders passed by the Supreme Court. The orders passed in this case. In this case, I came here. My petition was rejected. I went to the Supreme Court. SLP was admitted. The matter is pending before this court, and then a fresh notice is issued. What is the need for an interim order when the Supreme Court is in season of the matter? Yes. No, my lord. When your lordship says, we live in, my lord, we respect even the foreign courts. Look here, you disagree, your lordship disagree with me, but your lordship has to, my lord, your lordship has to listen to a critique. I am answering. Yes. The reason is, listen to the reason also. In presentia majoris, then the people are allergic to Latin. In presentia majoris, cessat potentia minoris. In the presence of a superior power, all other forum have lost their jurisdiction. And that is the foundation of CPC also. In CPC 1976 it was amended to expressly say that the pendency of mere filing an appeal will not amount to an automatic stay. And that is the reason where there was a clogging of the system. But the principle is, when a matter is before the Supreme Court and notice has been ordered and the matter has been listed a couple of times, it was not heard, then the parties should wait for the Supreme Court. If they wanted to proceed, they must move the Supreme Court. Now, my lord, now the question should be asked. Let me ask a question. Did this court ever ask a bank or financial institution, did you ever constitute one committee? No, my lord, your lordship said no question can be asked. I disagree. No. Questions. This is a platform. This is court means the judge, the litigant public, And my Lord, with all humility, Lord, should not mistake me, Lord, for not utmost humility. My Lord, the facts of the cases and MSME, I take your Lordship 13 to notice. Earlier judgment, your Lordship will find at page 201. 201. Yes, yes. Earlier judgment. No. My repetition, my Lord, at page 201. Where Maripoyo? 46. My Lord, 46572. 46572. I filed a petition here, it is pending here. Yes. 46752. Now, all humility, I should not be mistaken, all humility. Because I need to speak, because there is nobody else there to speak. If I don't speak, there is nobody to, all humility. This is my, I have seen it. Nobody is there. And that is why people are denied justice. The people are denied justice. No, my Lord, no. Your Lordship will find at 201. Ashok Rubber Factory, yes. Yes. Mariama Jovish is the first petitioner. The other is the second petitioner. This is my that is my entity only. I am a guarantor there. My husband's sir. I am not a Ashok Rubber is a partnership, proprietorship firm run by my husband. Ashok Rubber is a proprietorship firm run by my husband. I am the guarantor, and they proceeded against me. I am the guarantor, and the fresh 13-2 notice has been issued. There is one more matter is there. There is one more matter is there. There are two MSMEs. One is in my name, and the other is in my husband's name. In both, I am the borrower or guarantor. There's no company, my Lord. Ashok Rubber is only a proprietorship. They have simply used the name Ashok Rubber. Yes. SLP number I will give. Yes. Sorry. SLP number. My Lord, I give the SLP number. 1 second. My Lord, I'll give the SLP number. So, I'm sorry. Now, my Lord, all proceedings to be stayed. All proceedings to be stayed. And here, what is the amount due? My Lord, they have put my property for auction. That is a subsequent development after filing this. After filing this only, that application is there? No. Yes, auction notice is there. Yes. Yeah, fine. No. That is at page 219. Page 219. And here I inform them. Yes. There subsequent notice has been issued. Subsequent notice has been issued. Now, subsequent notices I may not have produced because it has been filed. It was filed when? It was filed. Roy, give the date. It was filed on, what is the date of filing? Yes. It was filed on 8/12/2025. 8/12/2025. This petition was filed on 8/12/2025. Now, my Lord, putting my Lord, all that I need that further proceedings, all proceedings under the SURFACE, I should be able to operate my account. The current account. Everything, whatever money was there was taken away. Nothing is there. They are free. But under the SURFACE, there is no express provision under the SURFACE whereunder they can attach and freeze the account. But the moment they classify the account as NPA, they took all money, and I am not able to operate my account. And all that time, my Lord, plead for is that all further proceedings be stayed. I should be allowed to operate my account. And the amount, you look at the loan amount, is only some 3 lakhs. 3 small amount. Only 3 lakhs. Only the. This is louder, my dear friend. Please be louder. They use the mic. When banks speak injustice, let the people hear it. No, you can use the mic. Just switch on the mic.
This is what my friend is supposed to complete, without submitting that. Now, wherein, yes, wherein your lordship has put a question, what is the immediate threat? Wherein the date of the auction notice, your lordship can see the 2nd of March. Now, my friend says that SLP has been confirmed. I don't know. I'm not receiving it. Anyways, there is no stay. Well, I don't know what the stage of my doubt, as long as the contentions in case both repetitions with regard to the challenge of MSMEs, both these repetitions. No, here 2 repetitions are there. Today 2 repetitions are there. Yes. No. Both by Mariamma Josh. Kindly see the prayers. On the basic prayer challenge is with regard to the MSME. And now my friend wants to have this court sit in over the judgment passed by the apex court in Rolix and some. This is what ultimately is seeking for. From which itself it can be seen that the challenge of MSME cannot be re-agitated again. Applying the Henderson's principle, already the exhibit article report has entered into, those issues cannot be re-agitated. Even though it is a very lengthy repetition, very short and simple thing is the challenge with regard to the MSME, that they were not granted the benefit. All these identical contentions were considered by this honorable court. I have produced that judgment. Now, with regard to 46752, I have produced exhibit R3A. If your lordship is pleased to look into, right from the Privy Council judgment has been dealt by this honorable court in that R3A judgment. All the contentions from my learned friend with regard to the apex court judgments, everything. So nothing survives. After considering all these contentions, I may be permitted to read the 11th portion. That is running in counter affidavit 26, my lord. Of 46752, page number 26. Can I read, my lord? 11 onwards. Doctrine of res judicata. Yes, my lord. No, I am referring to my counter affidavit. Yes. So, anyway, my lord, please to para 11 of my lord is referring to WBC 13154 judgment. So that 13154 judgment. WBC 13154. Then my lords may have kindly have a look at para 11. Judgment. Judgment only I am because considering all those conditions. The doctrine of res judicata rooted in
Which petition are referring to?
13154 WBC judgment.
No, which petition?
46752.
46752.
46752.
46752.
The doctrine of res judicata rooted in section 11 of the Code of Civil Procedure and reinforced.
Which page you are reading?
Paragraph 11 of the judgment.
No, which
That
page?
is page number 26.
Continuous page.
No, in my counterfeit, page number 26. Paragraph 11 you can refer of that judgment. 13154. Can I read? The doctrine of res judicata rooted in section 11 of the Code of Civil Procedure and reinforced by public policy mandates that a matter once finally adjudicated by competent court cannot judgment was referred. But in the instant case, the issue raised in the petition was directly and substantially an issue in the earlier litigations referred to above. While matters collaterally or incidentally in issue may not ordinarily operate as res judicata, matters directly or substantially considered as issue to the prior decision constitute res judicata. Their attempt to re-educate the same grounds is clearly equal res judicata and constructive res judicata. Accepting the contentions on behalf of the petitioner would mean that a litigant can go on filing cases despite dismissal of their plea if they feel that the decision is wrong, even without filing an appeal. And it will be the litigant's understanding that decides the maintainability of the subsequent challenge and not the inter partes judgment. Through each sale notice may furnish a fresh cause of action. Even then, an adjudication on the point already raised and rejected is clearly gone. None of the principles argued by the legal counsel for the petitioner, based on the authorities referred above, holds that a writ petition can be filed by the same person raising the same contentions against the same adversary. That's what has happened here. None of the exceptions stated for avoiding principles of res judicata applies to instant case. The second contention relating to challenge against the auction also cannot be entertained, as the contention of the bank is that auction is over, and it's a prior sought for the writ petition has been rendered infectious and the remedy is to challenge the same. Now, my lords, what happened? In the first stage of petition, the challenge was with regard to the MSME by the proprietary concern. In the second petition, the challenge was in this 13154. The wife has filed a petition wherein her gold ornaments are going to be auctioned by the bank. So at this point of time, challenging that auction notice, the petition was filed. So in that second petition, after dismissal of the earlier petition, the second petition on the identical grounds when filed. That is one. That number I shall provide. That's not produced because when the earlier before this 13154 judgment, before. Excuse me, I'm sorry. Yes, proprietor and proprietor. In which the content of the MSME was raised. So now, when that has been dismissed by the honorable court, now the wife has filed, pointing out that her gold ornaments are going to be auctioned, in which husband is also a petitioner. That's the judgment which I read out to your lordships. Wherein the same as the MSME contract, apart from that, auction procedure is only a formal challenge, but the main challenge was with regard to the MSME. So, in the light of the Crowley judgment, Krishnoma's judgment, Dushman judgment, and the Samar's concessions, or considering all these states, even though my friend had an argument that the principles of res judicata will not apply, and before the learned single we try to convince so many legal positions. After considering, that's why it's a very detailed paper considering all those conventions, judgment that was dismissed. Now they say that without proofing the writ appeal, they approach SLP. I don't know. Probably I am to receive the notice. Whatever that until and unless by laws, even if apex court has not stayed these proceedings, so that is order to court, the bank is at liberty to subject with the auction procedure. So my sample submission is that even the prior pleadings in the case, what they are trying to canvass is that this court has to revisit this judgment passed by honorable court. How that is possible? So my submission is that this is nothing an abuse of power of separate cause of action, and they can never challenge it before that. This honorable court only need to consider MSME, because MSME only High Court can consider, not by the DRP. That is true. But that my friend cannot re-agitate it again. Once those have attained finality, and until and unless the Supreme Court, even though my friend says that SLP has been preferred, until and unless that has been stayed, what prevents this court from proceeding further? So, my lord, this is nothing an abuse of laws of law, nothing survives this. Both the petitions are to be dismissed. Same party. My lord, my prayers are same. My lord, my 46752, which is filed by Mariamma Dosh. My lord will get a running page 5. Mariamma Dosh, Joshua Lawrence. In the other petition, page number 4. It is again by Mariamma Josh and Joshua Lawrence. Yes, my lord. In the first page, 46752, the prayers run from page number prayer number 30, page number 30. In the other case, the prayers run from 27 onwards. Yes, 28 onwards. My lord, my kindly see, first prayer, declare that the notification dated is unmistakable. Same ditto, 61 days, 31 days. That's MSM. Second one, in furtherance of the prior codings, asking this court to revisit. Third prayer, to declare that the entire proceedings, say 13.2, to issue a writ in the certiorari calling for the entire record classification and NPA, say. Then E, to declare that insofar as MSME Act and notification creates certain obligations and burden as against the bank. Same one. F, to issue an order direction calling for the entire record and proceedings leading to classification of NPA. Fifth, to declare respondent bank is entitled to enforce all remedies. So exactly the ditto prayers, one and the same. So nothing survives, my lord. Yes.
Petition number. Yes. Petition number 444635. Yes, and the other petition is oh, 1 second, my lord. There are two repetitions I'm searching, which is the last one. One second. Yes. Anyway, my lord, I take your lordship to writ petition number 46752. It was filed on 8th of December 2025. Yes. Paragraph 1, statement of facts. Petitioner number 1 is a woman and MSME entrepreneur engaged in the trade of various products, namely less known trade links. Petitioner number 1 registered registered her unit as an MSME. Then the copy of the Udyan certificate is produced as Exhibit P1. Exhibit P1. Yes. At page 35. The petition number 1 and the petition number 2 are two independent entities. Then, my lord, I read one more paragraph from the statement of facts. Exhibit P1, that is Udyam, the name of the enterprise, LSON, how to pronounce, I have no idea. Less known trade links. Then the micro unit, engage in the services. And the bottom, the name of the proprietor's name, all details are given. So this is myself, the first petitioner, Mariama Josh. Then, my lord, the second petitioner, I am reading one more paragraph. She availed, paragraph 2, she availed a loan by pledging her ornaments, including her daughter's tali. The gold loan came to be renewed. She continued to pay the principal and interest in terms of the sanction letter agreement regularly and without fail. However, her husband, suffering from a stroke, led to a huge amounts being spent on medical treatment, and she faced extreme difficulty in paying the installments on time. Accordingly, she met the officers of the respondent bank and explained her extreme financial stress. There is no word of denial of this. My husband suffered a stroke. I informed them. Yes. The petition number 2 is her husband, who too is running an MSME unit, micro by name, Ashok Rubber Factory, engaged in the manufacture of molded rubber pads and plastic pipes. Your Lordship will find at Exhibit P2 at page 36. Name of enterprise, Ashok Rubber Factory. Type of enterprise, micro, etc. Then order. Oh, yes. And order copy. Order copy. Yeah. Yes. With his incapacitation, as a result of the stroke, he too faced difficulty in servicing his loan account. So there are two MSME units, husband and wife. Both are engaged in two different activities. The wife is on trading, husband is on manufacture. And they are guarantees to each other's loan. I stood for my guarantee as for my husband stood guarantee for my loan. Then paragraph 3. Petition number 1, so to petition number 2, her husband approached the bank for seeking protection in terms of the notification dated 29/5/2015 under the MSME Act, which mandates that bank shall identify incipient stress of the MSME of an MSME and revive them by constituting a committee as contemplated by the notification. The notification especially prohibits classifying the account as an MSME as NPA, which the committee alone can do. Who can classify as the account of an MSME? Only committee and nobody else. That is what paragraph 14 of the notification says. I'll come to that later. If the committee, which is a judicial tribunal, can anybody deny that? Comes to the conclusion that rectification, restructuring, nay, resolution of stress is not feasible. It is empowered to permit recovery, including the particular modes since different modes of recovery are permitted by law. As aforesaid, the petition number 2 is an MSME engaged in the manufacture of molded rubber pads and plastic pipes. It registered itself as MSME in terms of the MSME Act and the notification thereunder. Then, my lord, yes, para 3, para 5, yes. As aforesaid, the respondent bank classify the account of the petition as NPA in violation of the prohibition contained in the notification. A copy of the 13-2 notice dated dash is by the respondent number 2 is hereby annexed. The petitioner replied to the said notice, pointing out that the notice is one rendered void ab initio, being in breach of the notification dated 29/5/2015, requesting that it be recalled and a committee be constituted to resolve this stress. The true copy of the reply dated 22/4/6/2024 by the second petitioner to the respondent number 3 is produced as Exhibit P4. I take your lordship to Exhibit P4. P4 is at page 41. Yes. Your lordship got at page 41. Yes. Yeah. And then okay, P4, may I read it, my lord? P4, yes. Yes. In the light of mid part, my lord. Before that, he is referring about COVID pandemic, etc. But yes, in the light of the current financial difficulties, at page 42. In the light of the current financial difficulties faced by us, we repeatedly requested restructuring of the loan accounts as per the RBI guidelines, so as to enable us to augment production, carry on the business smoothly, and thereby discharge the debt in a comfortable manner. We earnestly wish to settle the accounts at the earliest. It was with the intention that we sought restructuring of the loan accounts. In the above premises, the Division Manager Canara Bank, Kottayam, by letter dated 8/5/2024, required us to submit certain documents for considering restructure. We are earnestly pursuing the matter. We wish to bring to your notice the financial hardship we are currently facing. Despite these challenges, we are willing to make sincere efforts to regularize the account. We are committed to resolving the matter amicably. We propose a repayment plan wherein we can pay the amount monthly starting from July 2024 to clear the outstanding dues. We request the bank to consider this proposal and provide a favorable response. So therefore, my lord, an application was made earlier, and when 13-2 notice was issued, they made a request that the account be restructured. This is not a lawyer's letter, so you cannot have the perfection which can be expected of a lawyer's letter. Yes. Then, therefore, I made a representation. And my lord, I take your lordship to page 46. Page 46, it is be acknowledged by the bank. I would like to take your lordship to page 46. I would like to bring to your kind attention, my overdraft account is registered under the name Loan Trade Links, which is affiliated with MSME. I have enclosed a copy of the registration for your reference. Due to financial challenges posed by the COVID-19 pandemic, I am currently unable to operate my business effectively. My existing OD limit stands at rupees 7,50,000. Kindly request you to consider my unit as trust and facilitate the conversion of rupees 4 lakhs from my OD account into the term loan, while also allowing me to additional rupees 4 lakhs in ODs ensure smooth operation in my business. In accordance with the notification titled Instructions for the Framework for Revival and Rehabilitation of Micro, Small and Medium Enterprises, issued in May 2015. And they also, I would appreciate your prompt attention in this matter. For your reference, I have also enclosed a copy of the Supreme Court judgment related to this issue. So the matter that an MSME and entitled to the protection of the notification was brought to the notice of the bank. I am not conceding the moment that I am under any obligation to do so. I am under no obligation. This I argue for the rest of the people. Here I I brought to the notice of the bank that an MSME. But the notification, not the notification which a school student can understand in unmistakable terms says that it is optional. I take your lordship to page 70 because this mistake has to be corrected. My friend is now the basic jurisprudence has to be learned. Residuicata means on facts. There is no Dr. Residuicata has no application to the law. I have quoted Ulpian 1,000 times. Ulpian says a judicial decision can make what was white black, what was black white, what was straight crook, what was crook straight. Is pure English. Residuicata facit ex albo nigrum, ex nigro album, ex recto curvum, ex curvo rectum. So the court's authority is to err on facts. This is unbelievable. People hesitate to understand. A court can say 1 plus 1 is 0. I am bound by that. I am bound by that. Court can err on facts. Court can hold an innocent man guilty of murder, sentence him to death. It has happened. It has happened even in the case of that Calcutta case. A lift operator, he was an innocent man. Because I know a lawyer who conducted the case. He's an innocent man. He was fabricated. No, SLP number I don't. Yes. Therefore, may not residuicate coming. Yes. The copy of the order is. Yes. May not by oversight only it was not annexed. The SLP number is order is it pass on. So residuicata. Yes. There is no estoppel against law. That's a basic principle. Why there is no estoppel against law? Because when a parliament enacts a law, we are all symbolically present. It is with our consent a law is enacted. Yes. With our consent only the law is enacted. SLP number is SLP number Mariama Joshi is SLP number. Yes. Give the number. Give the order. Order. I'll give my lord. I'll give the order. Give the order. Order has the number. No, you give from your mobile. You showed me. Give me that. How? Order you showed me 1 minute. Supreme Court admitting the matter. No. You just get it. This is the order. Can you open it? This is the order. I'm passing on, my lord. Ashok Rubber Limited SLP number. SLP number. What is the number? 10986 of 2025. 10986 of 2025. I get a copy now. I send my clerk to bring it. SLP number. Yes. Just forward to me. Yes. So therefore this is a misconception. The Residuicata applies only to facts, not to law. If a judgment is contrary to a statute, it is per incurium. If a judgment has been rendered without considering a statutory provision, it is sub silentio. These judgments are sub silentio. Without is there any discussion about this notification? How an account can be classified as NPA? In the judgment, there is no reference about this para 2. I will only take 5 minutes. Let us be very clear on that. There are 3 scenarios. One is where I am a literate MSME. I am aware that I may not be going. I anticipate that I may not be able to identify. I will not be able to discharge my debts. An enterprise reasonably apprehends failure of his business or inability or likely inability to pay debts. Then I make an application. At that stage, there is no signs of incipient stress. There is no default. I take your lordship to paragraph 4. When such a request is received by the lender, the account should be processed as SMA 0. And the committee under this framework should be formed immediately. That is when there is no default. SMA 0. Look at my lord, SMA 0. SMS 0 means principal or interest payment not overdue for more than 30 days. When it is overdue for more than 30 days, there is a default. I can only apply before the stage of default. When I identify or my inability to make a payment. So there are first stage is I identify incipient stress when there is no default at all. Then the account has to be created as SMA 0, stage 1. Stage 2, well, stage 2, the bank identifies a default. No, my lord, this issue, this is the law of the land. This is where I am about. If your lordship is wrong, you have to correct it. Don't hesitate to correct it. No, my lord, it is not, my lord, there is nothing personal about it. No, and my lord, my lord, 1 second. I have a duty to tell the judge you are wrong. You have to correct it fearlessly. Yeah, no matter judge is pleased or displeased, I will say that. That is my duty as a lawyer. No, my lord, I am doing the same way I talk to Dibankar Datta, Chief Justice, Judge of the Supreme Court. I will talk the same way to Chief Justice of India. Because the judges has to correct themselves. There's a mistake. No, I am not rude to your lordship. No. I am not rude. I am very humble. Yes. What is the resistance to understand? If somebody doesn't, I will. No, my lord, my lord, if my, your lordship may explain, your lordship may, no, my lord, your lordship may, in your judgment, your lordship has judged it, I will never come. If somebody tells me, remember, you are wrong, with some reason, I will not come. When I come here, my lord, I am a divorce lawyer. I asked myself, your lordship, all questions be asked. Yes. No, that is, my lord, they took a fresh action. I have no money to time to pay. They took a fresh action. The new course of action. Yes. No. The DRT has no jurisdiction. Decide it. DRT has no decided. The DRT has jurisdiction. That issue is not decided. If somebody has to say, because the point is, no. My lord, the question nobody has decided. My contention is, see, defeat me intelligently. Give reasons. My contention is a child can understand. Insofar MSMEDR creates certain rights in my favor, cause certain obligations and burden as against the bank and financial institution, no dispute. The Act has not created any mechanism for adjudication of those disputes. My contention is this: insofar as it has not created a forum, the civil court jurisdiction is not outset. I have filed a suit. That is the. So then, my lord, now the question is, I 100% agree. The forum I should go is the civil court. Absolutely. Your lordship may dismiss my case saying that you go to the civil court. No. Therefore, my lord, unfortunately, no, my lord. Say, my lord, what I say is a thought which is slightly different from what you hear every day. That does not mean what I say is wrong. And if I am wrong, it must be corrected. You must be told, and I accept it. If I am wrong, I'm wanting to accept it. I'm just wanting somebody to point out, remember, you are wrong. For this reason, I'm waiting it. This Article 226 is a creation of a mistake. Because nobody discussed in the Constituent Assembly that by creating Article 226, we will be reviving the dual system. Did the Constituent Assembly debates? Alladi Krishnasamy Iyer said, this jurisdiction is quite popular. Writ jurisdiction is quite popular in the Chartered High Courts of Bombay, Madras and Calcutta. Nobody said a word. By creating Article 226. Article 226 is absolutely unnecessary. It is unnecessary jurisdiction. It ought to have been created. The reason is, well, your lordship may disagree with it, but don't hesitate to listen to me. Article 226 reopen a dual system. Now I can come to the High Court, I can go to the civil court. Why should there be two forums? That's a mistake. And all time is wasted. The petition has effective alternative remedy. Remedy is not the right word. Relief. Forum. No. No. That is why, my lord. But that is why I said your lordships can dismiss it, saying that yes. No. I am not saying that. I am saying that Article 2. That is where I am a little academically. I said Article 226 is only unnecessary, but it is created. No. Now the Article 226 is that gives a constitutional right to come to here. Yes. No, my lord. No, see, Matthew Dhanubara is not the litigant. That is what I said about 226 in my personal opinion. I may not go. Matthew Dhanubara is not the Mariama Jos. She has an independent right. She thinks differently. So she thinks she can come to the High Court under 226. No, my lord, that is the reason. My lord, that is why I said, there I would do fearlessly. Fearless. When I am convinced I am right, I need to speak. Come what may, heavens come down, I will do it. So therefore, here the notification here is simple. The first stage is I may voluntarily, I may voluntarily initiate the proceedings, which in this country nobody has done. Second stage is the bank noticing incipient stress. Yes, but your lordship's judgment does not reflect. I have taken your lordships. Therefore, they have a reason to. No. Parties are different. My lord, Venkatachalaya, the greatest of judges, Venkatachalaya in Andule's case, I brought it. Andule's case said that a judge should now take a pride in correcting his mistake. Yes, Venkatachalaya quoted. Yes. No, my lord. I will call Krishnaiyer. Krishnaiyer said. No. Krishnaiyer, my lord. Many judgments are challenged. Many judgments are, some are admitted. Depends on the. We have 17 Supreme Courts. 17 Supreme Court, it goes decide on which bench it goes. Supreme Court number 1 admit. Supreme Court number 2 dismiss. No. Nobody has applied. No. SLP dismiss doesn't mean application. No. Kunyama's case, people may not laugh it. Kunyama's case said that is the first case on the issue. Kunyama from the Kerala, when TCN Menon considered many forest cases and not even an act was amended. Then SLPs were dismissed. SLPs were dismissed against the High Court judgment. Then later the state filed the review petition. And the Supreme Court said dismissal of SLP does not lead to the merger. So then what is merger? What is res judicata? There's a difference. Res judicata, a cause of action is a disputed. You may disagree with me, but this is pure jurisprudence. You must be thankful to me by telling this. Res judicata means a cause of action estoppel. What is a cause of action? Disputed evidence. When it is subject to a trial, it undergoes a process called transit in rem judicatum. Thereafter, it ceases to be in existence and merge with a decree of a court. If the cause of action is found to be in existence, remember, if the cause of action is found to be in existence, it merge with the decree of the court. That's merger. If the cause of action is not found to be in existence, no merger, then only res judicata. So there is no res judicata or there is no merger unless the Supreme Court had heard the appeal and one way or other decided it. Dismissal of the SLP does not amount to res judicata or does not amount to merger. And it has been said in many cases, and recently, quite recently also in the Kodak distilleries. Entire judgment of the in Kunjagamad case has been quoted, paragraph 44, Koday distilleries. So therefore, dismissal of the SLP is no merger, no res judicata. So it has to be corrected now. And now I wouldn't have come, but for the issuing a fresh notice when the matter is before the Supreme Court. My lord, I will. No, I will verify, my lord. I will verify. I'll verify. I'll verify. There must be some reason, my lord. I am not able to. No, no. I will take, my lord. I will have a look at it. My lord. My lord. When you, no, my lord. Agreed. My lord. May I tell you very honestly, my lord. I was not keeping well. No. I have severe headache. No. Therefore, my lord, I didn't wanted to come here, but since there is a disposition, therefore I came. No, the other disposition, that's why I came. Now, my lord, now, 244, 24, my lord, let me, ഞാൻ പച്ച മലയാളത്തിൽ പറഞ്ഞോട്ടെ, നമ്മളോട് MSME-കാർക്ക് അവരുടെ കേസ് അനുവദിക്കുന്നതല്ല ഞാൻ സമ്മതിക്കത്തില്ല. അതുവരെ I will fight it out. Even if ഞാൻ ഒറ്റയ്ക്ക് മതി, ഒറ്റയ്ക്ക് അഹമ്മാൻ പറയല്ല, ഒറ്റയ്ക്ക് മതി. ഞാൻ ഒരു കാര്യത്തിൽ ഞാൻ, since I am convinced that somebody shows me I am wrong. My lord, this is the SLP copy. Ashok Rayurbat is a proprietorship firm only. So the name of the nomenclature is Ashok. Now the matter is before this. That is PK Krishnamar. Yes. My lord, the depends, my lord. Now the owner came after ever so many petitions, dismiss. Anybody would give up now? No, sir, absolutely wrong. Absolutely, paragraph 17 is you write 99%, then in one line you strike out everything. What my lord, a judgment, is it pronounce any word, it's a waste of stationery. I am making a comment. I'm sure I will be quoted. It's a waste of stationery. People court should not comment on matters which are not before the court. What only has been said in the first paragraph? Paragraph says no facts are discussed. Everything contradictory. My lord, one second. Yes, yeah. No. I'm reading from your lordship said this kind of judgments. Paragraph 3. I'm reading paragraph. No. I'm reading this. But I read one reason, my lord. Look at why I completely dissolve this judgment. Learned counsel of the parties in the instant appeals have also restricted their submission only to the said issue decided by the High Court, without addressing to other issues on the facts and merits of the involved in the writ petition. No facts were ever discussed. A batch of cases, no facts of any case were discussed. In paragraph 3, it is said. Then, in paragraph 19, the bank's lawyer said something, it was incorporated. The impugned order is therefore set aside. Since it has been admitted by the learned counsel for the respondents banks that in all cases proceedings under the Surface Act has already been concluded and the possession of the respective assets premise of the petitioners have been taken over We do not propose to remand the matter. And thereafter, this judgment is of no use even to the petitioners, appellants there in the Supreme Court. And look at paragraph 18, underlined. The court underlined the instructions/directions issued under the central government, etc., mandatory, etc. Then in paragraph 17, it says, underline, suffice to say, without any discussion, contradicting itself. No. Therefore, my lord, I am on a campaign. Burn all law reports. Save judiciary. Save justice delivery system, because this judgment serve no purpose. No, my lord, I rely on. This is the law. Statute is the law, not judgment. No, why should, my lord, I am relying on this. I am not a party to Cronet. I'm not. Why should I have concern? My lord, the doctrine of res inter alios. Res inter alios acta altori nasori non debet. Res inter alios. No, my lord, I believe if you, my lord, if lawyers by heart, Dr. Broom's legal dictionary, most of the problems are solved. Res inter alios acta altori nasori non debet. Res inter, res means thing, inter means between, alios mean others. Res inter alios acta altori nasori non debet. So, my lord. Yes.
Now why?
No.
Even this SLP, last make anything. What is under challenge is exceeding P20, the division when judgment.
No, I didn't complete it. When my friend come, I didn't.
Is asking me a question and support.
No, I didn't complete it. Yes. Why my friend is nervous? You be calm and cool.
Why you are
Eh? My friend has to be. You are appearing for a public authority. Yet I have a reason to be nervous because I am thrown out of my home. You have no reason to be nervous. You remain calm and cool. Yes, the concept is, I didn't explain the concept. There is a, because there's a concept is, in presentia majoris, cessat potentia minoris. In the presence of the superior forum, the subordinate forum has lost its jurisdiction. And this concept is even accepted when it even, the concept of respect to the, what is the foreign forum, what do you call that? Another terminology I miss, for it is on the lip of my tongue. That is respect for jurisdictions which are not subordinate, foreign jurisdiction. Doctrine of comity. Sorry, sometimes I miss the words. Comity, doctrine of comity. I'm not asking for comity. Committee is where we are under no obligation to, wait for the decision of the other forum. Suppose some same issue is before some other American court or Singapore court or British court. In matrimonial matters, it comes. But our court, our Supreme Court, wait for the decision of the foreign court. That's a doctrine of comity. This is a doctrine of subordination. When a matter is before the Supreme Court, no court, it is contempt. It is contempt of court, disrespect to the Supreme Court. And now, no. Therefore, your lordships is certainly under, in all humility, under duty to protect me. I cannot rush to the Supreme Court. No, my lord. Therefore, this poor lady. This poor lady cannot be expected. The Supreme Court should not be burdened. If your lordship reject it, then I will certainly go to the Supreme Court. I'm not. See, sometimes I passionately argue because that is not for my case alone. It is for the benefit of the litigant public and for our system. We love the judiciary. We love, my lord. Yes. My contention is sum and substance. That this man has even brought to the notice of the bank that I am an MSME. In the 13th notice also he replied. And in terms of that Sami Samars, yes, I am not relying the Sami Samars, but if even in terms of Sami Samars, which I completely disown, I'm protected. Then, in terms of the notification, I'm absolutely entitled to the protection. And your lordship, what I ask your lordship is, I have sought for in all subsequent petitions, I have made a specific prayer for them to state on affidavit the number of committees they have constituted. My lord, if they constitute one committee for any bank in this country, then all my petitions be dismissed. Otherwise, the court is hiding banks and denying justice. If I go around and tell the courts are for banks, ordinary people will not get justice. That is truth. The ordinary man will not get justice from any court in this country. That is the truth. And my lord, I am not just a beginner. I am a seasoned lawyer. I said, I came this court in 1979 as a litigant. 84 I enrolled. 42 years in the bar. When I make a statement that people do not get justice, only Ambani gets justice. That is why in every place I made Ambani a party. Because these are on record. Look at that, Ambani, 49,000 crores. 49,000 crores settled for 92 paise for 100 rupees. 92 paise for 100 rupees. Not even 1%. In another case at page 312. And in another case 35 paise. Therefore, that is why I made Ambani a party. And Attorney General I made a party. Because somebody from the state government and central government should come and speak. RBI should speak. But that has not happened. When the first principle is when an interpretation of a statutory provision is involved, the concept that notice to the Attorney General should go, so that there is a balanced decision. Yes, my lord.
Your lordship had asked instructions from the client. They're not able to give me any specific timeline, my lord, because we were expecting the money from the water authority, and they're not. Yes, my lord. Yes, my lord. The exhibit 9 and 10, my lord, they've acknowledged that there is money due to us. The last time the standing council had said that somebody else had to be impleaded, and that was also impleaded by your lordship, the last order. But they are neither. I had informed them in the morning also.
Now my difficulty is there is already an
That's what.
No, 3 crores 18 lakhs is the total outstanding.
No, it is 2 crores.
No, 3 crores 18 lakhs is the total outstanding. Moreover, there is an interim order. No.
Georgie John, my lord, he's not filed anything. So I am constrained.
Because
this
now
is what we were expecting. We just need time. Otherwise, we'll have to. I had informed them in the morning.
Because there is an interim order for paying 1 crore. They have availed various loans.
There is no.
Not cash credit alone.
They had filed
Not
from the water authority. He came and orally he said something, but he's not put it down on an affidavit.
Lord, he said, yes.
But terminated, my lord, after 3/4 of the work was completed. That also I have put it in my affidavit.
That is
I agree to that. But they have also said, I love it. I'll get those details.
Now my difficult. He's not coming. What we
I'll
can
send him a message in
do?
the morning also.
Because
I'll call him once.
even if it is.
Obliged.
Lordship, the grievances regarding the issuance of the Exhibit P3 demand notice against the petitioner, even after all the loan liabilities has been settled according to the one-time settlement scheme, Your Lordship.
This could release the title deed for the document. Then you get some more instructions. Lordship, I do not have instructions.
Lordship, it is November 2024 settle ചെയ്തു. OA March 7th 2025 dispose ചെയ്തതാണ് by recording this, Your Lordship. ഇല്ല, demand notice അയച്ചു. We have sent a reply to them. ആൻഡ് പലപ്പോഴായിട്ട് ഈ പറയുന്ന ടൈറ്റിൽ ഡീഡ് കിട്ടാനായിട്ട് ആ ഒരു റിക്വസ്റ്റും കൊടുത്തിട്ടുണ്ട്. ദാറ്റ് ഹാസ് നോട്ട് കൺസിഡർ. നോ, ഇല്ല, കിട്ടിയിട്ടില്ല. കാര്യം പുള്ളി പോകുമ്പോഴേക്കും പറയുന്നത് ഇഷ്യൂ ചെയ്യാൻ പറ്റത്തില്ല, ഇനിയും പെൻഡിങ് ഉണ്ട് എന്നാ പറയുന്നത്. എന്ത് ബേസിലാണെന്ന് വി ഹാവ് നോ ഐഡിയ. ലോഷൻ ദാറ്റ്സ് വൈ വി ആർ കൺസേൺഡ്.
The prayer in the writ petition is that housing loan is availed by the petitioner along with the second respondent who is her husband. They were in good times then. Thereafter, at that time of availing the loan, he agreed that he executed documents to the effect that amount is due. The question is that, I am ready to clear the entire dues. Wife, but the bank is issued exhibit P9 stating that they will not hand over the document to me, and it will be. Upright on the document. He was initially he agreed with the bank to collect the amounts from his pension. Thereafter, he filed a suit and got an injunction. And thereafter, when I got it vacated, joined. I don't know. I had a pension in the pension.
There is a suit pending filed by the husband.
No, that is vacated.
Another suit is pending between the husband and the bank. There was an injunction, but regarding recovery. No. My case is that I have paid the entire amount. Not regarding the title, regarding the recovery of the amount. There is a suit. One suit the bank has under to stop the recovery from my pension. Another suit is with the wife. Declaration of title. Yes. That suit is pending.
I am ready to undertake that, I will not. Once, it is decided, I will.
Yes. The property was purchased using three funds. One is that would be only for the purpose of getting the title of it. The loan was 10 lakh rupees. Total I have paid 14,74,000 to the loan account. And Chairman, is all right. As per my case, only a heavy amount.
Now I am residing in the house.
Regarding